Good morning, Your Honor. My name is Connor Blair. With me at the counsel's table is John Griffin. We represent the defendant in this case, AAC Investments. We also represent AAC's corporate tenant, Accurate Energetic Systems, AES, for the purposes of the motion, more definite statement of the AAC. Let me begin by saying that John and I and our clients have tremendous sympathy to the plaintiff in this case, as well as for the families of 15 other AES employees who died in the AES explosion of October 1st. Let me also say that we have no intention of delaying plaintiff's recovery from those who may be liable. We learned recently that the plaintiff is already receiving workers' compensation benefits from AES. Before the court today are two motions, as we discussed. We're going to be talking from my clients. We're going to be discussing first.
Well, let me interrupt you because I know that issue about his the decedent's status as an employee is one of the main issues you've raised. You just said that he's receiving workers' compensation benefits from whom?
From AES.
Okay.
So we represent AAC, who is the landlord of AES. The AES building is exploded in plaintiff's spot. AES building. Your Honor, let me also preface my argument by just noting that this is an important lawsuit. A lot is at stake, and it's likely to be just one, perhaps 16 similar lawsuits arising from this tragedy. It's critical that this court ensure that this case proceeds in an orderly manner and in compliance with the Tennessee rules. And those are the considerations that form the crux of both AAC's motion, more definite statement, and subsequently AES's motion to quash. Getting to the motion for more definite statement, Your Honor, the amended complaint is the operative complaint. Plaintiff filed a complaint, didn't serve it, and then a week later filed and subsequently served an amended complaint. So the amended complaint is what we're discussing today. And in the amended complaint, there's one cause of action for negligence, but the negligence theory is, and the supporting facts are simply not sufficient. The amended complaint states that an explosion occurred, and then recounts the myriad ways one could, theoretically or hypothetically, be negligent in the state of Tennessee. And then it concludes that AAC caused the explosion and is therefore liable for negligence, gross negligence, and punitive damages. Just last week, however, for the first time, plaintiff's counsel clarified plaintiff's theory of the case, seeming to abandon its theory that AAC caused the explosion in favor of the premises liability. They made this motion in their briefing in opposition to the AES motion to quash. But the amended complaint, the operative pleading in this lawsuit, remains too vague for AAC to respond to. And it contradicts plaintiff's counsel's briefing and their opposition to the AES motion to quash. Now, this matters because as the amended complaint is currently pled, it seems to suggest that AAC controlled the building 602, which is the building addition, which would make AAC the statutory employer of plaintiff's father. That matters because if that is the case, then this lawsuit belongs in the Court of Workers' Compensation Claims, and this court has subject matter jurisdiction over AAC. Your Honor, as I'm sure you're aware, a statutory employer is one who retains the right to control the work being performed and the workers performing. The amended complaint alleges, consistent with that definition, that AAC retained the right to control the work being performed in building 602 and the workers performed. The amended complaint is short, but it is replete with allegations tending towards that conclusion. Paragraph 1, for instance, says that AAC owns building 602. Paragraph 6 references building 602 as, quote, defendants AAC's factory. Paragraph 8 alleges that AAC, quote, was in control of and was the owner, operator, and manager of building 602. Honor, based on the insufficient allegations, we moved for a more definite statement. In opposition, plaintiff's counsel states that they seem to double down on their theory that AAC controlled building 602. Page 5 states that AAC controlled the building. Page 6 identifies AAC as, quote, the owner, operator, manager, a person in control of building 602. Page 9 states similarly that AAC owned, operated, and controlled building 602 and managed the factory where the explosion occurred. For these reasons, it appeared that the plaintiff was pursuing liability against AAC based on AAC's control of AES's building 602. As I mentioned, this theory would fail because this case would therefore belong in workers' compensation. However, frankly, we didn't think the amended complaint was pled sufficient enough to warrant even a motion to dismiss. So we asked for the more modest relief that is, my understanding, routinely granted in the state. Just asking the plaintiff's counsel to provide a more definite statement such that we can review and respond to it. However, like I said just last week, in opposition to AES's motion to quash the third-party subpoena, the plaintiff's counsel clarified their theory, admitting that they were traveling only under a premises liability and contradiction of their amended complaint, that AAC has no control over AES's production of building 602. For instance, on page 5 of that opposition, plaintiff's counsel states, quote, plaintiff has pleaded a viable Tennessee premises liability. This clarifies their theory. Then on page 14, they state, quote, plaintiff does not allege that AAC directed AES's industrial operations. Plaintiff alleges that AAC, as an owner of the property on which an inherently dangerous activity was permitted, had knowledge of the dangerous conditions, making clear that this is now a premise liability claim, and that AAC actually has no control. So although plaintiff's theory of liability has been clarified, the amended complaint, the operative pleading, remains too vague, too ambiguous, and not clear enough for us to frame a response. It's our opinion in the relief that we request. The complaint must conform to plaintiff's counsel's new theory of the case. We ask that the court grant the motion for a more definite statement, order the plaintiff to sufficiently plead a premises liability. This relief is necessary here. This modest relief is necessary here because our client, AAC, needs to know under what theory it is has to be liable in this case to frame a response. It's also necessary, and we'll touch on this more with respect to the motion to quash, but it's also necessary a more completed and more sufficient pleadings is necessary so the parties in the court can know the scope of discovery such that we are able to analyze and put some parameters on what is discovered in this case. Thank you.
Morning, Judge. My name is Taylor Pace. I'm here with Scott Armstrong. We're with Armstrong Lee Baker in Houston, and we're with Joe Griffith and Tanner Gibson at Hughes and Coleman. Before I kind of get into what's going on here, I think you asked the right question. You said workers' comp benefits from who? One of the big defenses that they're raising is that this court does not have subject matter, that this belongs in the workers' comp court. I think that, Judge, you hit the nail right on the head with that. And so by way of brief introduction, this is a real complex case. There's a lot going on. I'm going to simplify it just to a few bullet points right now. Because of multiple systemic failures at this factory, 16 people are dead. This is the largest TOSHA violation in history. People have died at this facility previously under very similar circumstances and explosions. And the president, CEO, manager, founder of the company have served time in federal prison for scamming the military and giving them weapons that were not up to snuff and not giving the military what he said he was giving the military. That's AES. That is not the defendant in this lawsuit. That's AES that ran the facility. But our defendant here is AAC. AAC is the premises owner And AAC knew about all of these things. And we know they knew about all of these things because the owner of AAC is also the owner of AES. Exhibit 1 to their motion is the lease signed by John Sonday, the man who served time in federal prison for scamming the military, on behalf of AES. And it was also signed by John Sonday on behalf of AAC. And I believe that everything counsel just argued gives you everything you need to know that they understand what the allegations are of this lawsuit. They know what they need to be responding to. The motion for more definite statement should be denied. There's fair notice of what our allegations are. There's no question what our allegations are. What's going on here is that their client has essentially instructed them to not participate in litigation without a court order requiring them to do so. And I haven't met Mr. Griffin before, but Mr. Yancey, Mr. Blair, they've told me that on the phone. They told me I could tell you that at this hearing, that's their instruction from their client to not participate without.
Let me make sure I'm understanding you. You're saying that defense counsel has told you directly that they're the owner, their ostensible ultimate client, Mr. Sunday has instructed them not to participate in any discovery in this case unless there's a court order.
They didn't say Mr. Sunday, but they did say their client. They weren't specific about who it was.
All right, go ahead.
And so that handles the motion for more definite statement. I want to get ahead of the subpoena issue because I think this is going to drive that point home when we talk about the subpoena. Videos or photographs of the explosion, security camera footage from that day, documents pertaining to work being done that day.
I'm sorry, are you now dealing with the motion to quash?
Yes, Judge, I apologize.
Sorry.
These are the things we're requesting our subpoena. Plainly discoverable. Simple. This is a softball subpoena. There's no way they're going to object to these things, subpoena. And they've refused to confer. They've refused to produce anything. They've refused to work with us. We don't have a single document. And so we can go by it, go through this today in this hearing, line item by line item, figure out what they need to produce, what they don't. But I think they should have worked that out with us. We've spent hours on the phone to get nothing. And so all of that, and from the outset, they filed their motion to quash without conferring with us, which is against the local rules. We think the motion to quash should be stricken. The motion for more definite statement should be denied. And we're respectfully requesting an order. We shouldn't have to do this, that they're going to engage in discovery. So if you have any questions, I'm happy to answer them. That's from the outset, that's what I've got.
Your Honor, Mr. Pace and I and Mr. Yancey, who's on the meetings, have had a number of telephone conversations. During none of those conversations has my client, have we relayed, our clients have not instructed us to not participate. To the exact contrary, our clients have an entire team of lawyers who have been working around the clock tirelessly, gathering documents, reviewing documents, and producing documents to various government agencies. Government agencies I didn't even know existed. With respect to this case, the thrust of our motion for an evidence statement is that this case the court needs to satisfy itself that plaintiff has established the court's subject matter jurisdiction. Unless and until that happens, the court can't require AAC to respond to the court cannot issue an order enforcing this in the case in which it lacks subject matter jurisdiction. Now, Your Honor, we can get to the motion to quash here subsequently, but I want to highlight that during Mr. Pace's argument, he asked you to deny the motion for more definite statement because it's seemingly obvious what plaintiff's theory of the case is. I'm not totally sure that plaintiff's counsel knows what their theory of the case is. They plead one theory. Then they double down on that theory in opposition to our motion for more definite statement. Then in response to a motion from a different entity, AES, the motion to quash, they come up with a new thing. Your Honor, we need to know what plaintiff's counsel's theory of the case is. That will inform both whether this court has subject matter jurisdiction, which is a critical threshold issue, will also inform whether or not these documents they're requesting are within the scope of discovery. The scope of discovery must be tethered to plaintiff's claim. Plaintiff's claim currently is that AAC controlled, operated, and owned the building. That is not what their discovery requests go to. And moreover, with respect to their discovery requests, to the extent that their theory of the case, this is a premise liability case, and AAC somehow knew what AES was doing, none of their discovery requests go towards any communications between AES and AAC. There is not one request that asks for documents saying, what did AAC know? What did they know about? And when did they know? They say that that Mr. Sunday signed the lease. That's not sufficient to pierce the corporate veil. It's certainly not sufficient to prove that AAC knew or had constructed. But like I said, Your Honor, we'll get to the motion to quash next. But for purposes of the more definite statement, our arguments essentially remain unrebutted. That the case, they've brought a case, they've identified AAC, they've said something happened, AAC must be liable. We submit that's not enough.
Well, let me ask this question because the complaint, the amended complaint, makes certain allegations and tells you more or less what you're saying is that there was negligence involved. And then you're saying that in the discovery requests or in response to the motion to quash, that they're now saying that it was a premises liability. Is that correct?
That's exactly correct.
All right, but it doesn't change what they allege in the original complaint.
That's
And
exactly.
Tennessee is a notice pleading state, is it not? In which we are only required in pleadings to put the other person on notice of what it is, the nature of the claims, and give them a reasonable short statement of what that is. It doesn't require detailed pleading of every aspect of their claim. And if someone makes a claim that is not later supported by the evidence, then they don't amend their pleadings to include an alternative grounds for relief, then obviously it's subject to a motion for summary judgment if in fact the proof at that stage is such that they can't sustain their allegation. What you're asking is for me to make them state that what they really want is what they're saying in their discovery, not what they've said in their amended complaint. Is that more or less it?
That is not it. As the complaint is currently pled, it appears that this case belongs to workers' compensation.
I understand what you're saying.
As plaintiff's theory of the case, they put forward in a brief to the court, were that in the complaint, it still likely would not survive because it lacks any kind of specificity as to who did what, when, where. Under Tennessee law, they must do more than identify tragedy and name a claim. All we're asking for them to do is amend their complaint to provide us actual notice as to who did what, when, and how that is negligent. With respect to, in our briefing, we talked a great deal about duty and how AESC has a duty towards its tenants and employees. It's a very modest relief. It will not slow down the proceedings in this case. I think they have a couple of weeks, 15 days to provide an amended complaint. And then we can, we're amenable to a shortened answer response timeline, and we can up to the races both with respect to litigation and with respect to the third parties.
All right. This is a very complex case. It's not the first time that I've dealt with the tragedies that occurred at this location. We had a prior case some years ago that more or less involved some of these same parties. I think they were under different corporate names at that time, but it was a similar type situation. And that litigation, I think, ultimately was resolved. In determining the rights of the parties, it's incumbent upon this court to try to make sure that both sides have an adequate opportunity to understand the evidence again that they're dealing with and what the other side is going to do under our rules of discovery. Under the rule for motion for more definite statement, which is rule 12.05, states if the pleadings of which a responsive pleading is permitted is so vague and ambiguous that a party cannot reasonably be required to frame a responsive pleading, the party may move for a more definite statement before interposing a responsive pleading. The motion shall point out the defects complained of and the details desired. If the motion is granted, then the order of the court is not obeyed within 15 days after the notice or within such other time as the court may file. The court may strike the pleading which the motion is directed or make such other orders deemed just. I think in this, because of the nature as was pointed out, if in fact the plaintiff was an employee of the defendant and as might be classified, then this case does not belong in this court. It belongs in the Court of Workers' Compensation, because by statute, all workers' compensation claims against an employer by an employee are required to be heard by the specific workers' compensation panel. For that reason, I think it is important to try to identify at this stage whether or not we have jurisdiction. So for that reason alone, I'm going to grant the motion for a more definite statement. I'm going to allow the plaintiff to have 30 days in which to make the responsive pleading. More definite statement, in other words. Now we move to the motion to quash.
Thank you, Your Honor. With respect to the motion to quash the subpoena, I think in light of the court's ruling, subject matter jurisdiction is in question, if not established. I would recommend that we wait and see what the amended complaint says. That will determine the scope of discovery.
You understand, I've not required them to make an amended complaint. I've only required them to make a more definite statement, which are two different things. So they may make an amended complaint, but that's up to them. I'm just simply ordering that I've granted your motion. I would agree, but by the same token, this is a case that I think needs to be moved along, and it does not need to languish on the court's docket. And, you know, if the plaintiff, I want to hear from them, as to whether or not they want to proceed with discovery while they're doing their amended complaint. And he's nodding in the affirmative, so I'm taking it from his nodding that he does want to proceed. So let's go ahead and deal with your motion report.
Okay. With respect to the timing here, plaintiff's counsel makes a lot of the statute of limitations expiring in October 10th, which is 5 months away. There's two things there that I think are important for purposes of this motion. The first is that AES, who is subject to the subpoena and who makes the motion to quash, and AAC, who they reference in their opposition brief, neither one of those entities, neither of my clients, are really concerned with the statute of limitations. We are not trying to run out the clock to say for our purposes. As your Honor has noted, AES can't be sued because they were plaintiff's father's employer. AAC has already been sued, so neither of my clients have any interest in delaying this case for purposes of running out the statute of limitations. I think the second point that's important is plaintiff's counsel is, I think, misframing why this case has taken 6 or 7 months to get where we are today. The complaint was filed on October 16th, but it wasn't served. They amended their complaint a week later, but didn't serve it until November 14th, so a month ago. On January 22nd, we filed our motion for a definite statement. We did so because we accepted service of the amended complaint. Plaintiff's counsel served the initial complaint. They served us with the wrong document, so we got 60 days to respond. Then in March, plaintiff's counsel served AES with a subpoena that is the subject of the motion. And at this point, Your Honor, the case has been pending for 5 months. We timely moved to quash the subpoena, and we worked with plaintiff's counsel to schedule the motion for a hearing. So they make a lot about the amount of time that has passed since they filed their complaint, but it has not been as a result of AAC or AES's delay, refusal to schedule this hearing. Your Honor, so there's not really a delay on the part of defendant or AES. And frankly, Your Honor, there's really not a rush. We're not at the rush stage yet. Like I said, AES has been working tirelessly to collect its documents, review them, and then produce the requested documents from government agencies. Should the court determine that some of these subpoena requests documents are within the scope of discovery once we have their more definite statement, AES is more than capable of quickly reviewing producing documents in response to those requests. But like I said earlier, regardless of the timing issue, AES can only be ordered to produce documents that are within the scope of discovery. Before we can know what those documents are, we need to know what the scope of discovery is, which I think we'll have a much better idea once plaintiffs' defense counsel has provided a more definite statement. But without any idea of what the scope of discovery is, we just can't know whether their requests come within the scope of discovery. 26.02, as I noted, 26.02 requires the discovery be tethered to the plaintiff's claim. And we need to know exactly what their claim is before we can advance responsive documents. Thank you.
Let me make sure I'm understanding. The subpoenas were not to AAC Investment LLC, the party to the action. One was to AES, and the other was to Fike's Corporation.
That's correct.
All right, so I just wanted to make sure I was clear as to who was objecting. So.
Yes, I believe both objected. We can handle the AES for now. That's easier. Steve Snyder for Fike. So the first thing I want to point out, counsel just mentioned that AES is more than capable of quickly reviewing the documents and producing them whenever it needs to. And so there's an argument in the motions about this being unduly burdensome and us having to pay for production, something like that. I think we can pass that. I don't know if they're withdrawing that argument. When it comes to neither entity being concerned with this statute, here's kind of what's going on. This facility is still operating today. A lot of our subpoena items are targeted at third parties who are present at the site, at the location, on and around the time of the explosion. And these are entities that AES and AAC are still doing business with today. And so I think they do have an interest in running it out. I think that they've got business interests, and I think that they're doing a favor for the people they work with at the facility by stalling this. And so all of this goes to exactly everything I was saying. They know what the allegations are. They know what the lawsuit's about. They know what the scope of discovery is. It's fair notice pleading standard. They understand what we're alleging. It's just drawn out the clock. So, and happy to answer any questions. That's all I got.
You want to be heard on Fike's?
Yeah, sure. Good morning, Your Honor. Steve Snyder for Fike, who is a non-party and not related to AES or AAC. We were served a non-party subpoena by the plaintiff's counsel. We filed a motion to quash.
So explain to me what I understand what AAC and AES had to do with this explosion that took place. What is Fike's position? What exactly was Fike's, and what is Fike's, and what were you doing?
That's what it's part of what we're trying to figure out, Your Honor. Fike makes, I know Fike, for example, makes equipment for video equipment and cameras. And I think there's a concern that there might have been some Fike cameras in the location. And so I know Fike showed up in I want to say a chemical safety board
memo that popped out in March, and then shortly thereafter we got this subpoena. So I think our name appeared in the Chemical Safety Board report, and so that's where we came from. The subpoena that Fike was served was for documents, but the first part had 25 questions, interrogatory type questions that were submitted to Fike, which piqued my interest because that's not allowed under the rules of civil procedure. So that's what really spurned our motion to quash those questions. Plaintiff's response, it appears that they have withdrawn those questions. So I believe those are withdrawn. That's not going to be an issue. The subpoena also requested insurance documentation, questions regarding insurance. That's not appropriate either under Tennessee law, Thomas v. Oldfield, or the Tennessee rules of civil procedure. I believe in the amended response, those requests have been withdrawn. So those are off the table. That leaves us with about 24 document requests. Fike as a non-party, plaintiffs must make sure, pursuant to the rule, they must make sure that they take reasonable efforts not to cause a non-party undue burden or undue expense. Undue burden, when you're looking at that, it's going to be proportionality, time and scope, and breadth. And when we're looking at the requests, the issue that's come about is to provide any and all, for example, maintenance records with respect to any maintenance performed at the AES facility. I don't know what that means. Any and all repair requests. I don't know what that means. The span is 11 years. And so what I've instructed my client to do, and what we have done, and I will present to the court, that Fike and Plaintiffs' Counsel have engaged in continuous communication regarding this issue. I sent this subpoena to my client. I'm like, go get me everything you can get me. And they're gathering documents right now. And I have a firm belief that once the documents get back to me in a format that I can assemble them, that I can have a meaningful conversation with Plaintiffs' Counsel, and that we can reduce and narrow the scope of the request to where they're happy, and we produce the documents, keep the court happy as well. Also, Plaintiffs' Counsel in the response, we talked about a protective order. They brought that up. I think we can get a protective order as well, because there's some proprietary information that, again, it's not super top secret stuff, but there is proprietary information that we just don't want distributed. Also, there's requests for like system architectures, and videos, and things of that nature. I'll need to get with Plaintiffs' Counsel to kind of figure out exactly what they're looking for. Like I said, we've been going on negotiations, not negotiations, but communications regarding the request. And frankly, Your Honor, I just kind of ran out of time. We did not want to delay. So I knew that this motion was set for this morning. So with agreement of counsel, we kind of piggybacked onto it. So we get this before the court. But again, I believe that we can start producing documents and probably start producing them pretty quickly. Probably within the next, I believe I can probably get documents to Plaintiffs' Counsel within the next 30 days. They can look at them. If they have objections or they want more things, I can produce them. I can do a privilege on things that they've requested. I don't have a problem doing that.
All right.
Judge, real briefly on the Fike subpoena, if I may. So what I'm hearing is that they're generally agreeable to producing documents related to this explosion.
That's what I hear.
And so what I'll be asking judges in order that they produce the documents that they believe are responsive to the subpoena, subject to objection. I'd ask it be done in the next 2 weeks. I think we could live a little bit more. This has been pending for quite a while. And I would like to at least start seeing where we are with the documents.
He said 30 days, you're saying 2 weeks.
If I may address that, Your Honor. So again, I need to get documents assembled. I need to send them back, make sure that I'm not missing anything, and then I get to the Plaintiffs' Counsel. I can't do that in 2 weeks. I do need 30 days.
I'm going to give him 30 days.
I understand, Judge. And in that regard, after that's done, if there's any issues we need to bring to you, because we're ruling at that point, that's when I'd say we do it. Otherwise, we can.
Well, both of these motions to quash, it seems to me that preliminarily I'm going to deny the motions to quash, but allow the parties to negotiate the exchange of the information and give them 60 days to try to resolve that. If there is an ongoing issue regarding that, then you can contact me and I will arrange a hearing. It may be out of this county. It may have to be in another county because I'm here for a month term of court, and then I move to the next county, which where am I going? In July, I'll be in Cheatham County. So, so I think that the simplest thing would be just preliminarily deny the motions to quash, but reserve both of the defendants or all the parties who have moved to quash, reserve the right to re-argue or to reassert their motion to quash. So I'm denying it without prejudice, but allowing the exchange of information to take place over the next 60 days, and then we'll go from there.
And so I understand your ruling, Judge. Are you saying that the non-party shall respond to subpoenas within 30 days and then work out disagreements within the remaining 30 days?
That's my point.
I understand. Thank you, Judge. I'm not
So if we're clear on the motions to quash, I think it is important to try to get as much relevant information. The rules of discovery allow for all you to discover any information that's relevant or might lead to relevant information. So they're extremely broad, but there is a standard by which you can become burdensome and overly expensive, especially to non-parties. So for that reason, I'm going to give you 60 days to try to resolve these issues about the subpoenas and expect that they be complied with. If there is an objection made to the broad or scope of that, then we'll deal with it down the road. So I want to give plaintiff the 30 days for their filing of their motion for bill of particulars of it, and then hopefully give some time after that for this exchange of information.
I understand. Thank you, Judge.
Anything else? For some reason I didn't think it was going to be that simple.
Just one thing, Your Honor. So we appreciate Your Honor's ruling of 60 days, 30 days to.
I don't know that you really appreciate
Well,
it.
I understand it. What I would ask for is a slight modification for AES. Their more definite statement will be filed in the next 30 days. At that point, we have 30 days to produce documents, and then an additional 30 days to negotiate. So our AES 60-day clock.
You have any problem with that?
Judge, my only issue would be that I think that the idea of the more definite statement is coming down to this whole idea: is this a premises case or not? Well, it certainly is. It's a premises case. Our pleadings are that they had control over the facility, and they're attempting to say that we're saying that they had control over the
The
people.
motion for a more definite statement, a more definite statement is not the same as the amended complaint. That's the way I read the rules of civil procedure. And for that reason, even though I've ordered you to give a more definite statement, it's just like in a criminal case. A more definite statement can be required to supplement what the indictment says itself, but it doesn't change the nature of the offenses. You have set forth in your amended complaint your basis for recovery. This more definite statement is an explanation of facts that you believe support your theory of recovery and give them notice of what your intentions are. It is not an amendment to the amended complaint. And for that reason, what you're asking is that once you have 30, let them have 30 days to file their their bill of particulars. And then from that point, you want 30 days to comply.
That's correct. And the reason for that is I think the more definite statement will give everyone a better idea of what their claim is, which will give us a better idea of the scope of discovery. And until we know the scope, a lot of their discovery requests appear to be fishing expeditions in search of other entities to sue, which is not AES's duty to provide, and it's not come with the scope.
Because I believe that all of the documents that are contained in our subpoena to AES are discoverable under theories that have been pled under the existing amended complaint.
Well, I'm not going to, again, AES is not a party to this action. So they're a non-party, and under the rules, basically, the rule 45.08 basically states that a person responding to a subpoena need not provide discovery of electronic. So on a motion to compel discovery or to quash, the person from whom the discovery is sought must show that the information sought is not reasonably accessible because of undue burden or cost. If that showing is made, the court may, and it goes on to talk about other things that I can do to specify conditions for discovery, including the allocation of cost. It is the plaintiff is arguing that their basis for the recovery is sufficiently set forth in the amended complaint. Your argument is essentially saying, yeah, but I don't agree with that being the basis of their recovery, and therefore I would like to have them file this motion, this bill of particulars, so I can find out if my theory is right, that they don't really have, that this court doesn't have jurisdiction. But I think in order to allow the plaintiff to properly file its motion for this, its bill of particulars, that it doesn't seem unduly burdensome on the defendant to produce the documents under the subpoena prior to the expiration of 60 days. So I understand what you're saying is essentially you would like to have your 60 days start to run after their 30 days. And I'm not going to agree to that. I'm just going to order that they have 60 days to respond. So you have 30 days for your bill of particulars. They have 60 days to respond to the discovery and any other issues. If you find that the motion for bill of particulars, I don't know why I keep saying that. If the bill of particulars sets out something that you think, this is exactly what I'm saying, and now I have proof, then you can renew your motion to quash. That's what I've said, and I will give you a date to hear that, even if it's all by Zoom. Y'all have Zoom in Texas?
We do, Judge. Although I prefer in person, but I'm happy to do by Zoom.
Thank you.
Well, I'm going to tell you that I went to law school. I'm born and bred Southerner, and I grew up in Houston County, from over here in Tennessee, but I ended up in law school in Houston. Long story. And all my friends down there made fun of me, but the year I took the Texas Bar Association, the highest score on the bar on the bar exam was made by Paul Sexton, who was one of my classmates at the University of Houston. He was a chemical engineer, graduate of Vanderbilt University from Nashville, Tennessee. So they had us all gathered there in Austin, Texas for the swearing in. And I know you don't really want to hear all of this, but anyway, he was asked to speak. He got to speak to the assembled group, and they had the Court of Criminal Appeals, the Court of Civil Appeals, and the Supreme Court of Texas up there. The Chief Justice of the Supreme Court was introducing him and said, now, our highest score on the bar exam was Paul Sexton. He's from Nashville, Tennessee. He says, but don't worry, I've checked, and he's wearing shoes today. Why are y'all laughing? Because that's exactly the response that all of those people in Texas had. So when I got back up here, I was doing research on a case involving jurisdiction. In Texas, it was a divorce case, custody case, and the Tennessee courts had asserted jurisdiction over the custody disputes. Texas had as well. Texas Court of Civil Appeals had said that they had jurisdiction. Justice Joe Henry was writing, he was long since deceased, but he was writing his opinion and set out all the reasons why Tennessee had jurisdiction. And at the end, he said, as for our esteemed brethren on the Texas Court of Civil Appeals, I would remind them that if it were not for the state of Tennessee, Texas would still be a Mexican province. So I photocopied that. I made a copy of that, and I sent it to every one of my friends in law school who had laughed at that and highlighted it. But anyway, I still have my Texas law license. It's rendered inactive, but I went through hell and high water to get it, and I wasn't going to give it up, even though I'm back here. So, anything else before we adjourn?
Nothing to the plan, Charles.
We'll prepare the order.
Thank you. I appreciate it. We're going to stop doing our circuit civil docket call. The next thing I have is our chancery docket.
Yes, sir.
Thank you, Judge. Thank you, Judge.